Weekly list fresh admission item number 1.
May it please your lordship. My lord. May it please your lordship.
Yes, please.
My lord. Item number 1, your lordship. The petitioner is there before your lordship only for a very short question involved. That when petitioner was working as a junior clerk, the only grievance of the petitioner that when the junior to the petitioner has been promoted and the petitioner has not been promoted, no reason whatsoever has been assigned as to why the petitioner has not been promoted and why the junior to petitioner appointment number 3 has been promoted. This is undisputed fact that I am at serial number 9 and appointment number 3 was at serial number 10. Your lordship may kindly see gradation list, page 6. I'll not take much time of.
You were already retired, I think, by the time you filed this.
Yes, your lordship. Yes, sir.
You come so late, sir. When was the gradation list published?
The order was passed on.
No. Gradation list was published when?
Gradation list was published
in 2002 itself.
No, that is there in.
You woke up 8 years later.
No, at that time, the matter of promotion was not there. He was promoted later on. He was only promoted.
Anyway, the district judge has passed a detailed order.
The district judge has only passed Annexure 3, page 9. Had it been a rescind order?
No, it's okay. What is your name, sir?
My name is Dhaneshwar Nag. Sir, may kindly see Annexure 3 only, page 9. That
but
makes
you can't come after so many years. Then you have to make all those other employees who will be affected by that parties.
I have made appointment number 3, who is immediate junior to me. And I came only after 1 year because the promotion they have made, that I have challenged. The gradation list I am not challenging. Gradation list I am placed above. Sir, may kindly see.
All this happened. Gradation list was published in 2002.
That is not disputed. Gradation list.
Once you know your position, gradation list, you can't challenge it after 2010, 8 years later.
Gradation list I am not challenging, sir. Sir, gradation list, I am the senior. In gradation list, I am the senior.
Okay.
Thereafter, they promoted serial number 10, but they left me, I am at serial number 9. That is my whole grievance.
When was the promotion made?
The promotion was made by order dated 87 by 2010.
And when did you retire?
I retired in 2013.
No. See, your representation was rejection. Rejection order was 11.
11 years.
29th March 2011, and you filed this petition when?
In
2 years later.
The question is only financial benefit. I am not.
What financial benefits, sir? Leave it all now.
No, sir, may consider Annexure 3. Yes. My prayer, sir, only Annexure 3, page 9 may be considered.
So we have not issued notice in this. I don't know whether that man is retired or he's still in service.
That notice I'll take.
No. Is he retired or he's in service?
My instruction that he is in service. A senior clerk working at CJM court. And he is not going to be affected. I have made him a party. Let him be promoted. I have no dispute over his promotion also. I have no dispute at all. I never claim that I may not be promoted.
Sir, there has to be vacancy available. Promotion should have been made. We don't know how much it is going to disturb everything. In 2022, if we start interfering like this, it will cause chaos. Which is why if you don't follow up these matters in good time, it will unnecessarily create huge disturbance. Earlier, only one man was getting affected. Now several will get affected.
I will be placed just above my immediate junior. The others are not. And
no, there must be vacancy. You are seeking promotion from which post to which post?
Junior clerk to senior clerk.
So there must be vacancy in the post of senior clerk. For
vacancy is there. For that only appointment number 3 was promoted. Vacancy was there.
What I'm saying is, we don't know if others have now got promoted. He must have got further promoted.
Because it only involves the financial benefit, no question of service benefit is there. Others are not going to be affected. Because I am not claiming any service. I cannot claim any service benefit. So only financial benefit And the district judge, Lanen district judge has passed order annexure 3 saying that your representation is rejected when I have made a.
All that will happen is your pension will be recalculated. That's all.
Yes, sir. Sir,
But why,
that may.
if notice has not gone in the last 11 years.
But this
9
matter
years,
has
9
come.
years.
This matter has come.
You have filed it 2 years after the impugned order was passed.
Therein I have made a representation, and
No, that representation got rejected in 2011 itself.
that is there.
You filed the petition only in 2013. 2 years later.
In between also, I have filed a representation that I have not annexed, but annexed.
No. What you have challenged is 29th March 2011 order.
But sir may consider any order which says that your representation is simply rejected. That cannot stand. It is a very unreasoned
No,
order.
come in good times for all this. 2
Let
years
them
late.
let them take a decision and take the pension
No,
of
that
the.
is over. That stage is over. Your representation was considered. The representation was rejected in 2011. You filed this petition already in 2013.
But my respectful submission, sir, this is not going to affect service career of other persons, because only the, as sir said, that only the pensionary amount may vary.
Again, this is suitability, right? Promotion, is it automatic?
Had they stated it in Annexure 3, the rate would have been different. They only
No,
stated.
I'm asking you, under the rules, is promotion automatic or is it subject to suitability?
This is merit cum suitability with reference.
So then it's not automatic. Then it's not automatic.
With
at the highest, you can only be considered for promotion.
With reference to seniority. Due weightage must be given to seniority.
Maybe. But
they have,
DPC has to be convened. A DPC has to be convened for your promotion now.
But they have neglected the seniority matter, has not been answered at all. My grievance still. My grievance.
Do you know what your ACRs were? Do you know what your ACRs were?
Ratio.
No. ACRs. What your ACRs are?
That
you don't know.
Character role.
This is not automatic. What we're trying to tell you, it's not automatic because your senior will get promotion.
Sorry, saying about the confidential character role.
That's right.
That they have called. There is nothing adverse. There is nothing adverse against me. I have clearly stated in my representation also that has remained unanswered. I have clearly stated that nothing has ever been communicated to me. Had it been communicated, I would have got a chance to make a representation to correct my CCR also. That has never been done.
It's gone in this for 11 years now. Yes, who's for the opposite party? Nobody. One of you will appear.
No, I'm all appearing.
So this is the district judge Bolangir.
Bolangir, yes. The private opposite
and then
party
opposite party 3
served.
has to be served. You don't know if he's there still or not.
Private opposite party number 3 notice is not yet served, I think.
No notice has been issued in the petition, sir.
No.
For 9 years, no notice has been issued.
Once it was listed on
he filed it 2 years late. He filed it after 2 years.
Defect to be removed within a week. That is the order dated 11th November 2014.
That I have removed.
Now defect must have been removed.
Sir, defect has been removed.
They ask him to consider the representation one again. All right, it will be approved. All right. You say for nearly 9 years now, no orders have been passed in the petition which challenges an order dated 29th March 2011, passed by the the decision contained in a communication dated 29 March 2011 from the Registrar Civil Court, Balangir, the petitioner, stating that the district judge, bracket opposite party number 2, bracket, has rejected his representation dated 1st December 2010, paragraph. Grievance of the petitioner is that he was senior to opposite party number 3 in the gradation list. And yet, opposite party number 3 was promoted as senior clerk, overlooking the petitioner. Paragraph. The petitioner was already 60 years old when the present petition was filed. Consequently, the petitioner states that he is not interested in questioning the promotion of opposite party number 3, but only seeking the consequential benefit of revised pension in the event he succeeds in getting his notional promotion from the same date as opposite party number 3 was promoted. Paragraph. Having considered the above submissions, the court is of the view that some reasons ought to have been furnished to the petitioner for the rejection of the representation. Consequently, the matter is remitted to the opposite party number 2 for a fresh consideration of the petitioner's representation dated 1st December 2010. A reasoned order will now be passed irrespective of the earlier rejection of such representation. The decision be taken not later than on the representation be taken not later than 4th April 2022 and be communicated to the petitioner not later than 11th April 2022. The court clarifies it has not expressed any view in the matter. If agreed by the order of the opposite party number 2, it will be open to the petitioner to seek appropriate remedies. The petition is disposed of in the above terms.
Item number 2. Item number 2.
None appears dismissed.
Item number 3.
None appears dismissed.
Item number 4.
Item number 4 is not a PIL, my lord. Wrongly it has been mentioned, and it is a National Highway Act under the case has been filed, my lord,
All
for
right.
compensation
Consequently,
and
petitioner
interest.
now states the petition has been wrongly indicated as a PIL when in fact it is a case against National Highways Authority of India. List before the appropriate bench on 28th February.
Item number 5.
Your lordship, earlier case has been posted for 28.
28.
Yes.
Even this is where
Item number 5.
During this case, my lord, the last occasion was directed whether that representation is received by the concerned person or not. To that extent, I have filed an additional affidavit clarifying to that extent, my lord.
so
That
there's
is
no proof of received, you have said. All right.
Yes, ma'am.
All right. All right. The petitioner's representation dated
25/6/21.
June 2021 shall be examined by the collector
My lord.
and district magistrate Jashpur. But you've still not named the encroachers.
No,
But so far in
yes.
para 5, my lord, I have categorically mentioned, and also in my representation that is also there in para 5, my lord. Clearly, I have mentioned.
Where is that? Para 5.
Para 5 at page 3.
No, not of your
Not
affidavit.
there.
Of your representation. wherever-
Representation, yes, my lord. To that extent, my lord, you kindly see the representation on extra 3, my lord, in the middle portion, second para, my lord, at page 20, my lord.
All right. And after issuing notice to the petitioner as well as the encroachers named in the alleged encroachers named in the representation, and after giving him the hearing, a reasoned order should be passed not later than 2nd May 2022 and be communicated to the parties not later than 9th May 2022. The court clarifies it has not expressed any view in the matter. The petition is disposed of in the above terms.
Much obliged.
A copy of this order be produced by the petitioner before the collector on 7th March 2022 for compliance.
Item number 6.
Yeah, please, madam. Whether my dependence on under Annex 5 my lord before the collector, that is a pending. That is regarding the non-implementation of the project work, that in the plot that has been assigned, but there is no such
Allegation
plot.
of fraud and misappropriation, my lord.
Yes, my lord.
Lokaयुक्त. Counsel the petitioner seeks leave to withdraw this petition, liberty to approach the Lokaयुक्त in accordance with law. This post office withdrawn with liberty is paid.
Item number 7.
But here the challenge is to an order passed by the initiating officer under 24(5) of the Prohibition of Benign Property Transaction Act. Similar matters your lordship has entertained in respect of the partners. Here is the partnership file. At page 121, your lordship may kindly see. Annexure 3 series, in respect of 3 partners, your lordship have entertained the writ petition.
My lord, let him appear before the assessing officer, inspecting officer. Annexure 1, page 30. 30, annexure,
Page
30,
100.
31, 32.
Page 121, your lordship may kindly see.
We're already entered in what, when are those matters listed?
My lord, this was fixed sometimes during that corona period and no further date has been fixed. Your lordship may call all these matters along with this writ petition.
All right, notice, Mr. Chimanga accepts notice. List along with, counter be filed within 4 weeks, adjourned for the next date. List along with petition civil,
1399 by 21.
yeah, 1399, comma, 1402
140.
and 10, no, and 10233. Sorry, 10223 of 2021 on 4th May 2022. Till the next date,
1401,
no,
1402.
right, till the next date, no coercive action shall be taken against the petition.
Oblige me.
After lunch.
Good afternoon. For hearing item number 1.
I am appearing for the petition number 1, 3, and 4.
All right.
Last occasion, my lord directed me to file our response to the complaints affidavit filed by the state government.
Right.
Meantime, due to my suffering from COVID, I could able to file with regard to two writ petitions.
All right.
And it has not come today. And give me 1 week time so that I can file can recommend next week, my lord. So that I can
This
file.
is a full bench, sir. It's very difficult to assemble.
But sir, for that reason, I am only praying for that. Due to my illness, I could not file.
No, sir. Actually, then you should have mentioned it at least. Then we don't have to sit like this.
No, my lord.
Least you should have done is mentioned it at least on Friday.
My lord, sorry, my lord.
No, we'll just hear the others because this is all 94, 97 petition.
Yes, my lord. The last occasion, they kindly see the order dated.
Let us hear the matter, sir. Whatever you have a copy of your rejoinder with you.
The
whatever you filed, you must have a copy with you.
The whatever filed, the copy is with me.
You read from it. No difficulty. You just read from it.
My lord. What has happened? Kindly see the order dated. If you will start, kindly come to the order number 13, dated 17/5/2019.
Right.
Lord, before my learned senior proceeds, my lord, it's my duty to point out, my lord, I am in the 2 matters of Balarpur, my lord.
Right.
My lord, in the 2 Balarpur matters, my lord, Balarpur now has been transferred, my lord, as I have been pointing out in all the sales tax matters vis-a-vis unit Seva, my lord.
Right.
This has been taken over by a new small entrepreneur from Hyderabad, my lord.
Right.
And my lord, there's an application filed with the government for waiver of the water charges, my lord, which is impugned here, which is part of the list here, my lord. And my lord, but for the panchayat elections and the code of conduct, my lord, the matter would have moved by now, and it has been processed by the office of the chief secretary, my lord, awaiting a cabinet approval and consideration, my lord. And my lord, several other companies are also being considered because this is revival of a sick unit, my lord. Therefore, my lord, the government is considering a policy, a wholesome policy, wherein the government is intending to grant certain concessions for revival of these sick companies, my lord. This is insofar as the 2 Balarpur matters are concerned.
All right.
Therefore, my lord, my humble submission vis-a-vis the 2 Balarpur matters would be, my lord, if the government grants me the relief there, I do not need to bother your lordship for the time being.
So the matter can taken up next week, or so that you can come prepared, or 1 week after.
No. Sir, this is. I just want to tell everyone that whatever difficulties you have, you do not have to wait for the bench to assemble on a day and then make request for adjournment.
I apologize.
No. Even today, I'm really inclined to impose heavy costs. Because you don't seem to understand what it is for 3 high court judges in different benches to come together to hear a matter. It's not so casual.
No, here
I'm a bit disturbed about the casualness with which you people are approaching this. This is not good.
I'm readying the matter. I am one of the petitioners.
I personally held your lordship in high esteem.
Not for esteem, sir. This is not about personal esteem or anything like that. Please do not mistake what I'm trying to say. For a high court to organize a full bench hearing involving 3 judges in different benches is not easy.
Of course. Sorry.
This is not like casual thing that every morning or every other day we can sit. It's not like that, sir. I have myself been a practitioner. I have gone through 3 high courts. In no high court is a full bench treated so casually.
My lord,
a full bench hearing is a very, very serious matter.
I have the honor to argue before your lordship.
Which is why dates are fixed well in advance.
Yes, madam.
Today's date is known to all of you months in advance.
Yes, madam. Yes, madam.
I am ready in the matter. I am the last item. Can I start? The point is very simple. There is an amendment to the Orissa Irrigation Act.
Before your lordship hears my learned friend, my lord.
Yes.
May I have a hearing, lord? The learned advocate general was to appear before for the state, but because he is concerned and he was appearing for the petitioners in the first 2 cases, he had to recuse from the case, and I have been appointed by the state government specially to conduct this case. And I had seen your last order of your lordship.
Right.
And accordingly, we had given the reason and the affidavit given by us.
Right.
There are two aspects, Lord.
Right.
The batch of writ petitions, they challenge the wires, the legality of the imposition of tax, and etc.
Right.
On the other hand, your lordship had taken a detour, saying that if the same treatment as has been done to SAIL and MCL can be meted out to the other petitioners, then we need not go to the academic questions raised.
Right. Right.
And accordingly, each of them had represented, at least 3 of them had represented, and some have represented in the meantime.
Right.
And we had taken a decision that as per our cabinet decision, it is only extendable to the public sector undertakings who are contributing in public interest.
Right.
To this society as well as to the government.
Right.
So far as the private companies are concerned, it needs another cabinet decision to be taken.
Okay.
Another cabinet decision. So as now the government cannot decide in their favor. And as your lordship knows, cabinet decision cannot be taken now because of the ongoing elections.
No,
so
if you say that the cabinet is now contemplating drafting a policy for extending this benefit to private companies, we'll record that.
No, not extended. To take a decision on that. That is what. To take a decision on that. No, Mr.
Monty, if at the end of this adjournment, the decision is going to be we are refusing any concession to them, then what is the point?
Yes,
then what are you considering?
There your lordship is correct, because now we have refused because of the cabinet decision. We have refused because we cannot extend unless there is a cabinet decision superseding the earlier one on 27th.
No, unless you, therefore, the whole purpose of a cabinet meeting will be to examine if the same benefit can be granted to
can be granted to the private sectors also.
So we'll have to record your statement that the cabinet will examine whether the same benefit can be extended.
Not that they have to examine. That's your lordship is right. So I have to take instruction in that matter when likely the cabinet can be sitting, or
whenever it can, the earliest whenever it legally can, once your restrictions on model codes and all are over. Because you have an urban body election, I'm told.
Yes, that's
so it will have to be after the conclusion of the urban body elections.
Yes, after the conclusion of the urban body elections, the cabinet will decide whether to extend or not.
What was Union of India's challenge about?
My challenge is regarding imposition of water tax.
Why are you aggrieved?
No, I am drawing water from an interstate river, Bonam River.
Meaning?
Means the Southeastern Railway.
Railways.
Yes.
Okay.
So they have demanded an amount of 4.5 crores way back in 2003.
Mr. Monty,
my lord,
if you could extend it to public sector, why not to the railway?
Why not South? That's what your lordship had made it clear in the each one will represent, and on that representation will take a decision. So Southeastern Railway, I don't think
there should be any problem at all.
There should be any problem.
If I take that concession, what they will do it prospectively from today. Waive it off.
This is about waiving these dues, which is subject matter of the petition.
No, I am challenging the legislative competence of the Amendment Act.
But end of the day, you're aggrieved by they are asking you to pay water tax, correct?
I am aggrieved by that because there was no scope of legislative competence so far as the entry is concerned, and Article 262.
So and it's taken a policy decision not to charge public sector
three aspects here, Milord.
No, if they say
water tax, Milord, three aspects here, Milord. One is the water tax, then comes the penal interest on it, and then comes the penalty, Milord. So there are three aspects.
So if water tax itself is waived, then there's a question of interest and penalty.
I am obliged, Milord. I am obliged.
Because I have not got any kind of communication from the state government.
You have to make a representation. Did you make a representation?
No, I have not made a representation.
Then, sir, how will they consider it? The previous order was only for everybody to make representations.
No, I don't want to make a representation because I want it totally to be declared void.
There is repugnant, there is a Interstate Rivers Act 1956. Now, in view of 262, Article 262, there is absolutely repugnant to this amendment. They don't have any power, legislative competence so far as rivers are concerned or interstate river is concerned. Your Lordship knows interstate river, state has no authority. There is a direct judgment, Constitution Bench 92 Supreme Court, which says, while dealing in Kaveri matter, they have dealt with this issue and said that they have already set as an ordinance of the Karnataka government, saying that they don't have the power in respect of interstate river. So now, admittedly, my river, which I am drawing water, is an interstate river. So there is a repugnancy here and occupied field. So this is that has to be heard on merits. This type of concessions they are giving, it is up to them. But the amendment stays. If the amendment stays, again I am aggrieved.
Then it's better let him start.
Lord, so far as his writ petition is concerned, Lord, Mr. Paul, could you give the number which writ petition you are?
4154, the last
4154, last one.
But I don't think that we have filed any return in that writ.
They have filed one counter and it has been adopted.
Counter has been filed, sir.
But what my learned friend says, I think this is something different from the general law. General law.
Lord, in fact, each of the writ applications, there is a counter, and then finally in Tata Steel, there was a general counter which attempted to answer all the questions.
But what my learned friend Mr. Paul is saying, I think his case stands on a little different footing than what the others are.
No, only different footing is his railways. And the amendment is the same amendment.
Same amendment.
No, he says that it is interstate, not applicable. That has to be examined.
I will also demonstrate that river is also not part of entry 17.
Whatever
it is by all the parties, we've also raised that.
I'll just take your Lordship 10 minutes to show the provisions and the Constitution. Your Lordship, it will just take 15 minutes. Your Lordship will just take up that Orissa Irrigation Act.
Right.
Your Lordship knows the concept is different from the object of the act and subject matter of the act.
Yes.
If your Lordship may kindly see the object.
Yes.
An act to consolidate and amend the laws relating to irrigation, assessment, levy of water rate and cess in force in different parts of the state of Orissa. Now the amendment starts. And to provide for regulation of use of water from government source. So what initially was the object of the act was to levy water rate so far as the dams are concerned, where an irrigation project is concerned, or anything that is man-made. It was never the object of the act to levy water rate so far as subsoil water, rivers, flowing rivers, streams and nalas. Now, this aspect of the Orissa Irrigation Act, the power they draw from the legislative field, that is kindly see, before that I'll just take another provision, kindly see section 4(6)(a), government water source.
Yes.
You Lordship got that?
Yes, please.
Government water source means any water source created naturally or otherwise by collection or deposit of water at a fixed place, any subsoil water, this is groundwater, or water in a state of running such as rivers, nalas, springs, streams and the like, which is other than an irrigation work and is the property of the government. The rider is that it should also be a property of the government. Now this amendment, which I am aggrieved. Now, because it includes other than irrigation projects, rivers, subsoil water, nalas, springs and streams. Now, kindly come to, your Lordship will kindly take up the Constitution, the 7th schedule. Your Lordship will kindly take the list 2, 7th schedule, state list.
Yes.
Your Lordship will take that entry 17.
Water, that is to say.
Water, my lords. Water, that is to say, water supplies, irrigation and canals, comma, drainage and embankments, comma, water storage and water power, subject to, this is important, my lords, subject to the provisions of entry 56 of list 1. My lord, so far as the Irrigation Act is concerned of 1959, the power legislative competence was there to enact that act. But so far as the Amendment Act 3 of 94, there was no legislative competence because the legislative field, river is not there. If your lordship will again see entry 17, there is no mention of river.
No, but water supplies.
Yes, water supplies, irrigation and canals, drainage and embankments, water storage and water power. All these are man-made. Nothing has been attributed so far as natural source is concerned. Because why I say this? Because entry 56 in list 1 somehow takes care of that.
No, that is only with the interstate.
My lords?
There is an interstate river.
Yes, that is 56. Kindly. So regulation and development of interstate rivers, river valleys. So there are also two things. One is interstate rivers.
No, the valleys of those interstate rivers.
No, maybe. And river valleys, to the extent to which such regulation and development under the control of union is declared by parliament, by law to be expedient in the public interest. Now, so far as entry 56 of list 1 is concerned, there are two acts. One is the Interstate Disputes Rivers Act 1956 and the Rivers Boards Act 1956. Already there is an enactment so far as taking care of the interstate rivers throughout India. Now, so far as kindly come to Article 262.
No, suppose this irrigation is from a river, like Mahanadi is an interstate river.
Yes.
You're drawing canals from the Mahanadi river as long as it flows through Orissa. Will it not be covered by irrigation and canals?
Yes.
So far as an interstate river, but it's still an irrigation canal.
Yes. The test is that the level of the irrigation project, suppose Hirakud. Now, Hirakud level is 630 RL. Now, if my drawing that water is below 630 RL, then I come under that irrigation project. If my drawal is over 630 or is beyond, then I do not come, I draw it from the natural source. That is judgment of the Supreme Court, 98 Supreme Court is also there. So far as Orient Paper Mill is concerned, there was a challenge and that has been approved by the Supreme Court. Now here the aspect which is concerned is repugnancy and Article 262. Your Lordship will kindly come to page Article 262.
No. So how are you getting your water is the question.
My specific stand is it is an interstate river.
No. Factually, I want to know railways all over Orissa.
It is not all over Orissa. It is only one point at Jharsuguda. For Jharsuguda railway station, it is under this Chakradharpur division, Southeastern Railway. They are drawing water from River Bonam. And that drawal is from 1887. It is not a fresh drawal.
That River Bonam is an interstate river.
Yes.
Oh, so it must start in some state, it will end here.
Chhattisgarh.
And it comes and joins the Mahanadi as a tributary.
Yes. So our stand is, it is above 630, factually. So I am not...
you mean Hirakud height is above 630?
Hirakud water height is 630 RL. If I draw
that's the maximum. There's the reservoir level you're talking.
Yes. If I draw water below 630.
Sir, in Orissa, I think never went to 630 even.
That is the standard. That is the standard they are measuring for this.
No, but in Orissa, factually, I think it never went. Only for a 1 month or something in September, it might reach 630. It never goes to 630.
But that
You
is
take the statistics of the Hirakud Reservoir.
that statistics it differs from every.
No, but it never. I'm saying even during the year, sir. Only a month or something it is near
yes,
above 600.
It is because of that rainy
Most
season.
of the year is below 600.
So
11 months in the year, it will be far below 600. Summer months, it might come down to even 300 or whatever, 400.
Less than that.
Less than that.
Yes, than.
Only in September months, it crosses 600, not even 630.
Maybe that it will differ from a month to month, year to year, it will differ. The whole idea behind this is, the challenge is, if the Interstate Rivers Act is dealing with that river and there is a provision under the Central Act, then this amendment will be repugnant to that Central Act. So if there is a repugnancy, then this state law, so far as legislative competence, will not be there.
No, if it's an irrigation canal.
If it is an irrigation canal, there is no difficulty. Then I have to, any person who is drawing water from irrigation canal, then they have to pay the water levy charges. Now, what they have done by including river, that is natural river, there is where the legislative competence is not there. Because the legislative competence, if they draw that legislative field power from entry 17, there is no entry or no field so far as river is concerned. Now, and that is also subject to entry 56 of list 1. Now, entry 56 also directly takes care of the interstate rivers and river valleys. And in addition to that, Article 262 clearly says that there has to be an act which will be made by the Parliament. So Parliament is only authorized. So the judgment of the 92 Supreme Court says, even if there is an entry 17 and entry 56, since Article 262 is there, it has to be done by only Parliament. So interstate rivers, the state will not have any legislative competence to make any kind of enactment. The mischief here is that by adding or making an Amendment Act 3 of 94, they have incorporated rivers and meaning to also incorporate interstate rivers, which has been deprecated by the Supreme Court, and similar ordinance by the Karnataka government has also been declared to be void. Now, if your lordship takes up Article 262, adjudication of disputes relating to waters of interstate rivers or river valleys, Parliament may by law provide for adjudication of any dispute or complaint with respect to the use, distribution or control of the waters of or in any interstate river or river valley. The specific power by the Constitution is to the Parliament. Now, if the specific power is given to the Parliament to legislate, the state under the State Act or state list will not have that power.
No. This 262 is for adjudication of disputes.
No, it is adjudication of dispute, use, distribution and control of water.
No, with respect to, sir, or complaint. So it is adjudication of a dispute or complaint.
No, it includes everything, because I'll just place that one para of the Supreme Court, 92 Supreme Court. It will be clear. I'll give a note. I'll just place it, because that is where we draw our point for argument.
Because as I understand, water tax is a very common feature all over, right? So the sources of water, not always groundwater. I think groundwater constitutes a relatively small percentage. I don't know what is your statistics. In a water supply in a state, there will be several sources. Groundwater is just one of them.
Yes, for industries, they are using now
Largely
groundwater.
it will be rivers, it will be ponds, it will be tanks, it will be other sources.
Yes.
And those are all located inside the state itself.
Yes, so far as ponds, maybe they are private ponds, obviously state has no power. But so far, if it is government owned and lakes, and the government has power. But so far, what I am saying is, if it is a natural river, it is nothing man-made. No amount of investment by the state has been made for supplying water. Question of fee will not come.
No, but how do you say no investment is made? That's the whole point. How will state reach water in your taps without
No. So far
pipelines,
as consumption of water, so far as the household and agriculture is concerned, they are not taxed. That is another part, because municipality provides, they are taxed.
Yes.
That is a different aspect altogether. Here the question is about an enactment relating to a natural river where there is no embankment or an anikette or a dam.
No, let's take Jharsuguda Municipal Corporation. It's a corporation now? Jharsuguda Municipality. All right. So it must be collecting water tax as a municipality.
If they are providing water to your doorstep, they will collect because they have set up a meter and they collect it.
So why are you any different? You are a company, your railways, right?
Yes.
So to your railway station, they have to put some pipe only and supply.
Sorry.
Even to supply to your railway station, they have to take it through a pipe only.
Yes.
So
there's a motor installed.
So why is it any different then?
My lords?
How is it different? It comes through a pipe only to your premises.
No, the question is about not bringing the water. Question is about drawal of the order, point of drawal.
No. Then for everyone, point of drawal will be Mahanadi River or some other Brahmani River or Baitarani River. Everything is interstate.
No, that is not the issue. Issue here is whether the state government has any authority or legislative competence so far as taxing that water, natural water. It is not a question.
Sir, ultimately the water that flows in your tap is natural water only. Nobody is giving Bisleri water in your tap.
I hope now that scheme has been now adopted by the state government of giving water, this drinking water in the tap.
Drinking water.
No, even the drinking water is purified river water.
It is all RO water.
No, that's right. It's a natural water which is purified.
Yes. So now this 92, this judgment relates out of this Kaveri dispute, water dispute. Now, this is the constitution bench judgment, 92 Supreme Court 522.
One minute. Where is that? You have to give us copies.
But in Balarpur's case, I had filed 3 compilations, my lord, for the honorable judge's consideration, my lord. All the 3 compilations in spiral I had filed, my lord.
All right, let's see. Mr. Mohanty, have you studied this or you needed time for all this? Mr. Ramakant Mohanty.
Please unmute.
You'll have to unmute, Mr. Mohanty. You're not audible.
But am I audible?
Yes.
Now, so far as this case is concerned, what my learned friend is submitting now, that is not, I don't find in the writ petition. Look at in the writ petition, the original point which was raised in all the writ petitions, that it's from the natural source. If your lordship kindly sees paragraph 21 of his writ petition, he has summed up. Paragraph 21 of his writ petition, he has summed up. Entry 17, he says there is no public interest. So that is what is going to be decided now. And so far as the factual aspects are concerned, I have not filed a counter in this case.
Your reply, Mr. Mohanty, your reply was filed by the executive engineer. It means that there was a committee constituted as per the previous direction of this court, which was a fact-finding committee. And the sole dispute is whether the petitioner was lifting water from Hirakud reservoir or not.
Yes, that was the issue. Now
the committee held that they are lifting from Hirakud reservoir. So whether that what he says that whether he will come under entry 17 or not,
yes,
it is in Hirakud from Hirakud reservoir. That would be the sole dispute.
And here in his case,
Justice Rautre, I thought he was arguing that he's lifting straight from river Bonam.
Not from Hirakud reservoir. Hirakud dam.
His case is factually, he is stating factually different in this sense. He is raising water from river Bonum. And he says that it is a natural source and you cannot tax. That is
correct. That is his sole point.
That is his point. Now, if he says that because I have to file a counter, then this your lordship says, as your lordship rightly said, that 630 is the point, and those things we have to disclose. That what is the
please see the counter filed by the executive engineer at page 3, sir.
Yes.
Internal page 3.
Yes.
Running page 63, I think.
Right.
During the spot inquiry, last sentence.
It's a 3-page affidavit. Is that the one?
Yes, sir.
That agreed before the committee that they are lifting water from Hirakud reservoir.
Yes. Well, this is a general affidavit which was given on behalf of the opposite parties.
Basically, they have adopted.
Yes, adopted. But so far as the factually distinguishing features are concerned, we have not filed a detailed counter in this case.
No, during the spot inquiry, yes, Justice Rautri, you're right. It says during the spot inquiry, the railway authority along with their officers were present and agreed before the committee that they are lifting water from Hirakud reservoir.
And on the next page, sir, last paragraph 1, as
further they state, that's right.
Southeastern Railways draws water from the Hirakud reservoir, which is a government water source.
Correct. Then where is the question, sir? Not from the Bonum River.
Yes.
Not
Para
from-
6. There is no such river named Bonum.
No, there is a river, Bonum.
Anyway, that's what they say here.
How can they?
In the locality, they call it Bedan River.
I've said it is, some place it's called Bedan River, some place it's Bonum River.
Anyway.
I've stated that also.
Anyway, they're saying you're not drawing from the river from the reservoir, but you're from the reservoir. Once it's from the reservoir by your own contention, then it is not interstate river that you're drawing from.
No, it is an interstate river.
No, everything is, sir. What is this? I mean, one river may flow through 6 states. You mean say none of the 6 states, nobody can charge anything? It cannot be.
No, they cannot charge.
No.
Your lordship has see this judgment. I'll just read
We're not getting a copy of the judgment only.
But that is not the point, I think, which my learned friend has taken in the writ petition. Writ petition is that natural source, that point of natural resource.
A natural source. I say it is a river, not an irrigation project.
You yourself concede, sir, from the river, nobody is going there and drinking from the river. From the river, it has to be brought to your Jharsuguda railway station or somebody's house or somebody's factory. Some pipeline has to be laid.
Yes, there is a motor rate since 150 years back. I've stated that.
Then
even before the Irrigation Act came in. And even the Hirakud project was not constructed. It was only in 60s. So I'm drawing water since 1880 to 87.
No, Hirakud was constructed in 1946 or 47.
Yes.
No. It was in 60s.
Not in 60s.
No. Early 50s.
Commissioned in 60s.
May I just suggest one thing?
Apart from that.
Yes.
May I just suggest one thing? Since your lordship has rightly asked me a question that whether I'm factually prepared. Actually, we have not filed the counter. It has not been prepared. To be honest, Lord, I have entered appearance today. But so far as the other question is concerned, because why I had said, your lordship had specifically directed in the order that this point will be decided before going to the merits of the case. Obviously, it is correctly, because if this is decided, no need to go into those academic questions. But since my learned friend is now insisting that no, he will not go for a compromise or any arrangement or like sale or MCL, he has to challenge, then I need to file a counter in this case. Your lordship, kindly, I'm sorry, I could not inform your lordship earlier, but so far as this case is concerned, a factual counter is necessary.
No. So let's be clear, Mr. Manti. See, there is a counter filed by the executive engineer.
Yes.
Main Dam Division, Burla. Then there is another affidavit by the all of this for the state. There's another affidavit of the Chief Engineer, Water Services Officer of the Engineer-in-Chief Water Resources.
Yes,
Bhubaneswar. It's a 3-page affidavit.
Yes, Lord. What has happened, Lord, it's really a conclusion that they have filed it generally in all the cases to be adopted everywhere. But I beg to bring to your lordship's notice that this case, if my learned friend goes to the other point, it needs a specific count. Because those are in the general line where your lordships were discussing about the natural source, and thereafter came to a conclusion that let us try if state can take a decision. And accordingly, sale, in case of sale, MCL and others, we had taken decision. Now it is pending so far as private sectors are concerned.
So adjournment is inevitable. I think we'll have to draw a line now. No further adjournments. Whichever is the next date, we're just going to go ahead, sir.
Yes, that your lordship may make it clear.
Yeah. Even Balarpur, Mr. Das.
Milord.
If they don't take a decision, you go ahead with your arguments.
Yes, yes.
I'm obliged. Milord, then may I request Milord, Mr. Mahanti, Milord, if he can instruct the Water Resource Secretary and the Chief Secretary to process that, Milord, because
I have presented your lordship with my difficulty only because of the elections. Your lordship may give that breathing time only. Then thereafter, I will see.
All right, Mr. Ramakant Mohanty, learned senior counsel, who is appearing for the state of Orissa in these matters,
along with Mr. Arnab Behra.
Advocate, states at the outset that the state cabinet would have to take a decision on whether the benefit extended to the public sector companies can also be extended to the private sector companies, some of whom are the petitioners before this court. He further states that in view of the ongoing elections to the rural bodies and the elections to the urban bodies that have been announced, such cabinet decision cannot be taken till the conclusion of those elections. He further states that although the counter affidavit filed in one of the cases was adopted for other cases, given the averments in some of the petitions, including one filed by the railways, being WP Civil 4154 of 2003, a specific counter affidavit will have to be filed by the state to give a para-wise reply. Paragraph. Mr. Aditya Das, learned counsel appearing for Balarpur Industries in OJC 1899 of 1996 and OJC 6503 of 2000, states that the company has been taken over by a private enterprise, another private enterprise.
A new private enterprise.
And a representation has been made to the government to waive the water tax dues. He states that the petitioner is therefore awaiting the decision of the government thereon. In reply, Mr. Ramakant Mohanty, senior counsel, states that such decision also can be taken only after the cabinet is able to meet. Paragraph. Mr. Sarangi appearing for the petitioners in OJC 10916 and
Item 3 and 4. Item 3 and 4.
1093.
1903 of 95 and 3178 of 1995 states that rejoinder has to be filed in those matters and prays for some time. Paragraph. It is therefore inevitable that the present proceedings have to be adjourned. Stop. Before the next date, the state of Orissa will file its affidavits in all petitions wherever it chooses to do so. not later than eighteenth April 2022. Rejoinder to the said affidavits be filed before the next date. Paragraph. The decision of the cabinet, both as regards the extension of the benefit, question of extension of the benefit made available to the public sector companies, to other private sector companies, as well as the decision in regard to the two writ petitions of Ballarpur Industries, will also be placed on record with the said counter affidavit. The court also requests parties to file the respective written submissions, enclosing copies of the decisions they seek to rely on before the next date. 9th May, sir. 9th May 2022. All right.
It's very embarrassing to request your lordship. Can it be something else? Because April end, I think the elections will be over. So 1 month time thereafter, I think.
April end. I thought the urban body elections are.
Urban local body election is in May. Urban local body. Now panchayat election is going on. In May, the urban local body election.
Oh.
1 month.
So which is that window then? Whole of March?
No. After this March, April and May, that will be election months for urban local body.
2 months for urban local.
Because several municipalities and corporations, BMC, CMC, both, it will take some time. Lordship can end of May or June first week, it will, I think.
No, in that case, the cabinet will not meet till then.
Cannot take any decision on this type of subjects, cabinet.
Till May?
No, there is a gap between panchayat election and urban local.
So what is that gap?
What is that window?
That gap, I think
it's in March.
March.
To put it honestly, my lord, it will be little dicey to take a decision there. If your lordship kindly, with your kind permission, if your lordship keeps it to the after the election, then a concrete decision will be taken.
Then this April 18th, you cannot file then.
So far as filing of counter.
No, without a decision, how will you file a counter?
No, decisions I can. Decision. But so far as counter in Mr. Pal's case, we can.
Also, same problem.
Same problem.
No. So tell me, when is the election actually getting over?
No, I thought that by May it will be over. So I was praying that end of May. So June, if your lordship posts it, I think it will be all right. Then we'll be ready. We will not.
June is holiday.
No, the reopening of the holiday, your lordship can.
No, reopening is 21st. 20th June is reopening, sir. The whole of June is gone.
25th or 24th, like this, your lordship.
Then we can have it on 21st June, but the dates for filing affidavits will be when? Unless you give me an idea, when is the urban body election coming?
May I suggest one thing? Let the filing dates be 21st on the reopening, and 1 or 2 days thereafter, your lordship may fix it for hearing.
All right. It should be filed by 21st June, instead of 18th April. Then list on 28th June. All right.
28th. Much obliged. That will.
All right.
Obliged.
Sir, pranam.
Yes.
Item number 8.
My lord, I direct to state going to take instruction on 31st January 2022 million. This is a PL matter, million. What happened? The opposite party 4 to 6 are carrying a hat on Gochar land by violating under section 3 of the Orissa Government Lands Act. That the keystone of the land is Gochar. They have not taken to permission of the collector for a deregulation under section 3 of the Orissa Government Lands Act. Now also no site plan has been approved by the collector. They are carrying on construction over the Gochar land.
All right. The petitioner's representations dated 16th and 26th November 2021 will be examined by the collector.
Yes,
Collector Kalahandi.
Collector Kalahandi, and after issuing notice to the petitioners and opposite parties 4, 5, and 6, and after hearing the parties, will pass a reasoned order thereon, not later than 5th June 2022. The decision being made available to the parties not later than 12th June 2022. The court clarifies it is not expressed any view in the matter.
Orders item 9.
None appears dismissed for non-prosecution.
Item number 10.
May I plead your there is some defects, my lord. Serial number 6 and 7. In the meantime, matter may be taken up next in the
No, this defects were pointed out long ago, sir.
My lord,
More than a year ago. What's the matter about?
Eviction of encroachers. The alleged encroachers are not.
No, there may be parties.
Yes, they are parties.
But what is your representation? Has it been delivered? No proof of delivery.
Annexure 6, page 27.
Yeah, no proof of delivery of representation.
No, there is no proof.
Since there's no proof of delivery of representation, it's not possible to issue any directions to the collector Mayurbanj. Consequently, the petitioner is permitted to make a fresh representation. And after following upon or following up on it, to seek appropriate remedies in accordance with law.
Item 11. Item number 11.
None appears dismissed for non-prosecution.
Item number 12.
None appears dismissed for non-prosecution.
Item number 13.
None appears dismissed for non-prosecution.
Item number 14.
Lordship, appeal forum is there, Lordship. Liberty may be granted to file
The
appeal.
petitioner seeks leave to withdraw this petition, with liberty to file an appeal.
14 and 15 same, Lordship.
Disposal is withdrawn with liberty is proper.
15 also same.
All right.
Item number 16.
The impugned order is Annexure 7, page 50. Impugned order is Annexure 7, page 50.
Yes.
By which my representation for fixation of pay on third promotion has been.
Why is it before a division bench? I don't understand. Why is this before a division bench? No, why is this before a division bench?
Employee or judicial.
Oh. All right. When did you give your representation?
That representation is Annexure 4, page 4.
That's 2018, sir. What were you doing for 3 years?
Thereafter, the decisions sought for
what? You're not audible, sir. I think we'll have to reconnect. We'll pass it over.
Item number 17.
My lord, this is PL matter, my lord. My annexure 3 and 4 pending before the opposite man 2. 2, my lord. Collector can apply, my lord. That is a private land enclosed by canal land enclosed by the opposite man 5, my lord. Where the obstruction of the villagers not move freely from one place to another, my lord. That is total obstructed by the opposite man 5. And my application is pending before the opposite man 2, my lord. Not annexure 3 and 4, my lord.
What's the date of this annexure 4?
Annexure 4, my lord, that is 15/1/2021. Under 15/1/2021. Annexure 4, my lord. Page 40.
Proof of delivery of this
Yes, my lord.
representation.
Yes, my lord. Proof is, my lord. Page 16, my lord. I have also.
Some postal receipts is put.
Yes,
Yes,
sir.
yes.
Postal issue is there, my lord.
Yes.
All right. The petitioner's representation dated 15th April. 15th of January 2021. Should be examined by the collector.
Again, applicant implemented as apply open 2, my lord.
Collector Kendrapada bracket Office Partner 2 and petition notice to the petitioners as well as opposite party number 4. A reasoned order should be passed thereon not later than 9th May. Not 9th May. 6th June. The decision shall be made available to parties not later than 13th June. The court clarifies it is not expressed in you.
Oh, dear. Oh.
I may be excused, item 16.
Carry on, carry on.
Item number 18.
I may be excused, item 16.
We'll come back to you, sir. The connection was not clear.
Item number 18.
Item number 18, my lord, challenging the Form D of Orissa Civil Services Rehabilitation Assistance Rules 2020. I have not filed the second copy. In course of the day, I will file it.
It's all right. Tell us what the matter is.
Yeah, let's see. In this matter, for providing employment under rehabilitation assistance schemes, there is a rule for Orissa Civil Services Rehabilitation Assistance Rules 2020. You will see for providing employment. Kindly see the rules. Rule at page 15, rule 6.2, rule 6.1. First, the application for employment under these rules shall be submitted by the eligible family member of the deceased government employee in Form A of these rules, along with the following documents to the appointing authority. First, A, legal year certificate issued by the Tahsildar concerned. B, medically unfit certificate issued by the Medical Board of District of Permanent Residence of the deceased government employee in Form B of these rules. In case the spouse of the deceased government employee is medically unfit for appointment under these rules. C, nomination by the spouse or by the other family members where the spouse is not alive of the deceased government employee in Form C of these rules, nominating the applicant for compassionate appointment under these rules if applicable. Now, sub-rule 2 is on receipt of the application, the appointing authority shall verify the details furnished by the applicant, accept information content as serial number 6 and 8 of the application form, and determine the eligibility of the applicant by allotting points in the evaluation sheet given in Form D to these rules as given below. A, if the total points allotted to the applicant.
Anyway, it's all right. You say notice, Mr. Who
Extra copy be sought, because no copy has.
Mr. Das accepts notice. Copies of this petition be served. Reply within 8 weeks. Rejoined of the next date. List on 4 July.
Item 19. Item number 19.
This is the housing scheme was introduced by the Special Planning Authority Baleshwar, and the plot were allotted. Some plots were not allotted. So some those are allotted is not completed within 2 years according to the provision. So now the vacant spaces are pending, and the water logging are there and creating some unhygienic situation. So they have agitated before the authorities.
Where is the proof?
My lord, that is the provision under Your Lordship C, page 16. Annexure, that is 1, that is clause 13. That is all the plot, that is the residential plots will be allotted. That will be the housing, the house should be completed within 2 years from the date of allotment.
Proof of the representation having been made.
Annexure 3, my lord, the petition before the collector.
Left, there's simply a stamp, there's no signature. There's only a
stamp,
stamp, no signature.
This is your proof, Your Lordship C, central receipt is there below. It has been
There's no
written.
signature there, sir. It's only a rubber stamp.
Rubber stamp is they have given. This is a public representation. So your view lordship said, then I will also file a fresh appeal because they've received, but not signature is not there.
Counsel for the petitioner states that petitioners will make a fresh representation to the opposite parties, state, and after following up on such representation, seek appropriate remedies in accordance with law.
And my lord, after that is receiving, the debt may be free to disposal of that.
No, first he makes
Your lordship. I will
disposed of in the above terms. All right.
Item 20.
Yes, sir. So this is a PIL matter, and the petitioner has approached this honorable court for removal of illegal encroachment on the embankment road on the Daya Canal, my lord.
What canal?
The Daya Canal, my lord. The encroachments are there on the embankment roads of the Daya Canal. Lord, the Daya Canal was built, was made for irrigation purposes, and this starts from Barang to Jatni, my lord, where the primary aim was to help in the irrigation purposes for the villagers. But in due course of time,
you didn't make any representation.
Lord, I don't have a representation. I'll take instructions from it.
Why not? First, you should make a representation on these things, sir.
Lord, I'll take instructions on the representation.
No need to take instructions. Just make a representation. Ask them to first make a representation.
Lord.
The petitioners are permitted to make a detailed representation on the basis of the present petition itself, naming the to the collector Khurda, is it? The collector Khurda.
Yes.
Bracket opposite party number 2, and after following up on such representation to seek appropriate remedies in the course of law. This post of is withdrawn to party.
Item 21.
Obligation.
Mayor, in this case, I have sought for a modification of order dated 13/4/2021. Sorry, 19/1/2022.
So this is virtually a review petition.
The fact remains, which has not been considered, that I was not noticed to the hearing on that day.
No, we heard you very patiently. What is this? I was hearing you and we went on and on.
No, my lord, I have given that document where I have been noticed by writing and two notices.
This is having
by
a second
SMS.
round by filing what you think is only an IA, but it's actually a review.
Will unnecessarily lingering, my lord. Filing review will unnecessarily linger.
No. This is a review disguised as an interlocutory application for clarification. The court is not inclined to entertain this application. Dismissed.
Item 22.
May I please, your lordship? This is a PIL petition for providing basic facility for the person with disability.
You served a copy on Mr. Rautre, Mr. Buddhadev.
Malats, we have already received the copy. I'm appearing
What is your stand, please?
Malats, I've submitted a letter issued by the commission today morning by way of a memo.
Where is that?
I've already submitted the letter of the commission, my lord.
No, you have to say good quality ramps. Okay, they've given a whole set of instructions.
My lords, which has already been issued on 24th January 2022.
Mr. Suhail?
Your lordship, actually, in most of the polling stations, these facilities are not available.
Can you just give a sampling of those polling stations?
May your lordship, may it come the day after tomorrow, I will give photographs.
No, you pick up 2-3 panchayat constituencies.
Your lordship.
And in that constituency, tell us in the booths, what is the arrangement made?
Your lordship, day after tomorrow, I will provide that.
Counsel appearing for the State Election Commission on advance notice has placed before the court copy of a letter dated 24 January 2022 issued by the SEC to all collectors asking them to make arrangements for making the electoral booths in the Panchayat Raj institutions, elections to the Panchayat Raj institutions of 2022. Accessible to differently abled voters. Paragraph counsel, the petitioner states that notwithstanding these instructions, arrangements have in fact not been made for the differently abled persons. He undertakes to place and record photographs of a sampling of such voting booths at his request list on. We left on Thursday.
Obliged.
So that will be 24th. Oh, 17, sorry, 17.
Obliged.
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 When is your first polling day?
16th.
All right, 17th, all right.
Obliged.
Admission item 23.
None appears, dismissal, not prosecution.
Item number 24.
24, my lord, on the last occasion, that is your 10th
Mr. Mishra wanted time to seek instructions. All right. Maybe he has no instructions. We'll pass it over once.
Item number 25.
None appears, dismissal, not prosecution.
Item number 26.
My lord, item number 26 on behalf of Vishwajit Mahapatra kindly taken up next week.
No. Tell us what the matter is. Tell us what it is about, madam.
I prefer next week.
No.
The allegation of corruption in midday meal program.
It's a 2013 matter. Yes. If the cause of action still survives, it will be open to the petitioner to approach the Lokayukta. The petition is disposed of.
Item 27.
None appears, dismissal, not prosecution.
Item number 28.
None appears, dismissal. Oh, 1 minute. This is some amicus. No one is appearing. Mukund Madhav. Just going to prep. You have to file and follow up thing on this.
Yes. Status report is of the year 2014.
14, yeah. You
Yes.
say Mr. Manthi states that he'll file an updated status report informing the court of the developments since the previous date of hearing in 2014. On previous hearing on 10th November 2014, at his request, based on 2nd May.
Item number 29.
None appears to numbers.
Item number 30.
None appears to.
Item 31.
Very please, Your Lordship. This is a PIL matter, my lord, and as per my instruction, my lord, the cause of action still survives, and the opposite party number 2 has filed the counter in the meantime. Let them serve us a copy, my lord. This is with regard to the construction of road, my lord, National Highway. The noting is that the OP number 2 has filed the counter. I have not.
That road is still not been constructed.
No, my lord, some portion after issuance of the notice, my lord. Yesterday I got the information that after
Give us
issuance of-
photographs. Give us photographs. Who is doing it? NHAI.
I'm appearing for the opposite part number 3. Orissa still explicit. Opposite part number 2 is NHA.
2 is NHA.
Opposite part number 2 is NHA.
What is your instruction?
My lord, as per my instruction, my lord, from 13/1/2017, the agreement between NHI and me, my lord, has been foreclosed, my lord.
Oh, so you are no longer a party now.
Yes, my lord.
Opposite party number 3 informs the court that the agreement between the NHAI bracket opposite party number 2 and opposite number 3 was terminated in 2017 itself.
Yes, my lord. 13/1/2017.
On 1/3.
1/3.
13th January 2017, and therefore they are no longer involved in the project.
These are the letters.
It's okay. None appears on behalf of NHAI today. The petitioners are, counsel of the petitioners is requested to present before the court the latest photographs, which will show the court the progress made in the construction of NH 215/520 from Rajamunda to Rengalbeda in Sundargarh district. The registry will contact the standing counsel for NHA and request him to remain present to the next date.
Mr. Amitav Das is standing.
Mr. Amitav Das, all right. List on 8th March.
Grateful.
Item 32.
May I
Item
please, sir?
32, on behalf of Union of India, I have e-filed the counter affidavit. I've served the hard copy on my learned friend.
All right.
Just
Counsel
now I
just states that he has today served.
Your Lordship, the hard copy.
Just now I received the copy of the counter.
All right. Rejoinder will be filed before the next date. How urgent is this?
Lordship, this is in a form of a PIL.
No, what is it about?
No, it's in this, I'm challenging the amendment introduced in the Motor Vehicle Act. Your Lordship.
Right. List on.
My lord directed to file the affidavit.
They filed it today, 10th May.
Item 33.
Please, my lords. Lords, I beg to appear on behalf of the petitioners in the matter. Lords, we've just been served with an affidavit yesterday by respondent number 3.
All right.
Lords, in the meanwhile, my lords, I may also, my lords, even though I don't have a copy of the order date, but today, my lords, the Karnataka High Court has also struck down a similar, my lords, act which made that, my lords, took away the distinction between a game of chance and a game of skill.
All right.
I'll place that on record, my lords, along with my rejoinder.
All right. Rejoinder will be filed before the next date, 10th May.
Much obliged.
All right.
Item 34.
Item 34, Your Lordship, I seek on pass over, my lord. My learned senior will conduct this matter.
All right.
My lord, one more thing, my lord. Item 24 will could not join due to internet connectivity issue. My senior could not join. Serial number 24, my lord. He also
Passed over, sir.
My lords, my lords.
My lord, in item number 34, we have not filed the counter affidavit. Can your lordship grant some more
All right.
time?
Last opportunity to file a counter within 8 weeks. Rejoined of the next date. List on 12th May.
35.
But in this case, no counter affidavit has been filed yet. And your lordship have issued notice on 23 November 2021.
All right. Last opportunity to file counter within 4 weeks. Rejoined of the next date. List on 26th April.
Okay.
Item 36.
May it please your lordship. My lord, in these cases, there are twofold prayers.
No, they're not
First is
filed
to-
counter yet.
Yes, they have filed the counter. I have filed the rejoinder, and virtually they have accepted my prayer that there is no provision in the Orissa local laws for formation of association of allottees, and that the very own Orissa Apartment Ownership Act that has several shortcomings and deficiencies for which they are bringing a new act, and the law department has vetted it. So these impugned rules which have been brought in 2021, that is admittedly in contrary to RERA Act. I'll just place 3 provisions of the RERA Act, and my lord, it will be clear. The association is to be formed
My lord, before my learned friend begins, with your lordship's permission, my lord.
Yes.
Before my learned friend begins, my lord, with your lordship permission, my lord. My lord, the second matter on your lordship board, which is tagged up together with this, my lord, which is WPC PIL 18799 of 2021, my lord.
Right.
My lord, there I had filed an IA 1398 of 2021, where your lordship had directed to file their objection. They had already filed an objection, but my IA for intervention has not yet been allowed, my lord. And I would like to place an counter, my lord, to assist your lordship if your lordship so allows, my lord. Just to before you, because my lord,
whom are you for?
I'm appearing in the first matter, my lord.
Sorry?
In this entire batch, the first matter I am appearing, we have recently appeared. So we may be given an opportunity to file a counter because there are allegations against us as well. So just 2 weeks is all I seek, my lord.
No, whom are you for, Mr. Mishra and Mr.
I am for one of the builders, that is OP number 4.
Oh, I see.
My lord, in the second rate,
opposite parties. So we will assist your lordship, my lord. 2 weeks is all I want to file a counter, my lord.
And Mr. Monty?
my lord, I am appearing for a confederation of builders, my lord, in the second matter, which
All
is
right,
a
all
PIL.
right. So let them file. No harm in hearing it.
Since the state itself has admitted
Still,
to these things,
yeah, the builders are the constituency that is going to be affected. You are one side. You are for the apartment buyers.
My lord.
So
here
the
problem is that here the petitioner who had booked a flat in the year 2011 till date, even after payment of the entire sum, he has not been able to take the flat because of this deficiency.
That's why he doesn't want a long. You see, Mr. Gautam Mishra and its senior counsel appearing for opposite party number 4 in 38186 of 2021, and Mr. Monty appearing for the interveners in IA number 8552.
My lord, 13908, my lord. The second
13908
case.
of 2021 are permitted to file the replies to the main petition itself. 13908 of 2021 in WP Civil 18799 of 2021 are permitted to file replies to the main petition within 4 weeks. Rejoinder there to be filed before the next date. List on 5th April.
My lord, it's not prayer. Only a letter of the RERA to the IGR that may be complied with in the meantime. My lord, page 70 of my writ petition, the second writ petition, letter dated 14/5/2019. The RERA had written to the IGR that you should not register any sale deeds where the associations have not been found. But despite that, the IGR is continuing to register the sale deeds, and he has even not filed the counter here.
IGR is different from the state.
Yes, my lord.
Why?
They have not filed the counter till date.
IGR.
Inspector General of Registration.
IGR is not party.
Yes, he is a party.
No, the Inspector General Registration is a state functionary.
Yes, he is the OP number 3.
State, yes.
No, this, my lord, at the instance of a few people, why should registrations be stopped? I'm just wondering, my lord.
It is at the instance of the Odisha RERA only, not instance of my lord. My lordship,
that is for
I'll
the
just
state to
say
look
it's
into.
subject to the outcome. I'll just show one paragraph. I'll endeavor your lordship.
My lord,
Page 70,
my
your
lord,
lordship.
before that, may I only clarify? I'll only clarify, my lord, just because the premise itself, my lord, I'll only wish to bring it to your lordship notice. The premise of my learned friend is that Odisha Act is in violation of the RERA Act. That's the premise that he's dealing with. Until and unless that has been decided by your lordship, whether or not the Odisha Act that is being impugned here is indeed in contravention to RERA, which is not, my lord. And let us be heard. And it is not. The premise itself is, may I with all utmost respect, my lord, is flawed.
It is a central statute. The state act cannot override the RERA. I want the RERA act
Fair
to
enough.
be complied
We are
with
not
letter
standing
and
on the way,
spirit,
my lord.
as it,
My
it
lord,
is. And the Odisha RERA directed the IGR, you comply with the provisions of section 17 of the RERA Act.
It will all be considered once they file the reply.
Now, my lord, the problem is some sub-registrars are refusing it, some are registering the sale deeds. It is creating a very difficult situation. My lord, I'll show one paragraph only at page 70 of the writ petition. My lord, kindly, I'll endeavor your lordship, page 70 of my writ petition, annexure 8.
Which one, the first one?
My lord, second writ petition, 18799.
Well, since RERA has also not filed the affidavit, my lord, RERA is being represented by Mr. Mohanto is there also, my lord.
Page 70, letter dated 14/5/2019 to the IGR. If your lordships have got it. Yes, my lord. They quote section 17 of the RERA Act, and then, my lord, last paragraph they start. The above section thus prescribes that the promoters are to execute registered conveyance in respect of common area of the real estate project in favor of the association of allottees and hand over common area to the association of allottees. Thus, the promoter shall not have any ownership right over the common areas or built up areas whatsoever. However, it has come to the notice of the authority that promoters, while executing conveyance deed, are mentioning in the deed that the promoter shall have ownership right over the built up areas and common areas, which is violative of the provision of section 17 of the Act. Such conveyance deed, when presented before the registering authority, should be rejected. Accordingly, I would request you to instruct all the registering authorities to reject the registration of conveyance deed in respect of the real estate project when presented to them, if the conveyance deed mentions that the promoter shall have the ownership right over the built up area and common area.
Which registrars are following, which are not? How do we know
No
that?
one is following. Hundreds of sale deeds are every
You
day.
just now said some are following, some are not. That's what you said just now.
Petitioner's case, in very own petitioner's case, I have not been able to register, my lord, since 11
in
years.
your case, they are not.
Yes.
But there is a restriction on the registering.
Yes, hundreds of sale deeds every day are being registered in violation of this letter of RERA. Hundreds of sale deeds in real estate projects. Not a single day registry has stopped.
My lord, two short points, my lord. Number one, my learned friend is trying to rely on a 14/5/2019 letter, which is already almost 3 years, my lord. That's number one. So there cannot be any urgency at the moment. That's number one. Let me just complete. Let me just complete. Number one.
All right, we'll just ask them to file specific replies. Say Mr. Mohit Agarwal pressed for implementation of a letter dated 14th May 2019, written by the Odisha Real Estate Regulatory Authority to the Inspector General of Registration, stating that registering authorities should reject registration of conveyance deeds which are contrary to the section 17(1) of the Real Estate Regulation Development Act 2016. Correct?
My lord.
According to him, this instruction is not being followed. And
Lord, for RERA, Mr. Mohanto is there.
Yeah,
So-
stop. The court, without expressing any view on the submission of Mr. Mohit Agarwal and only to ascertain the factual position, the court directs that in the reply to be filed by RERA to the petition, the reply to be filed by the RERA as well as the Inspector General of Registration to the petition, this specific aspect will be adverted to.
Indeed, your lordships.
Grateful, my lord.
The petitioners
Counter to be filed within 4 weeks, my lord?
Yeah.
Grateful.
Petitioner first filed a writ petition to establish the real estate appellate tribunal. It was established. Then I filed a writ petition to direct the state government to formulate the rules for execution. Then that was done. Now I have to do this only to get one flat, my lord. Since 11 years, he has been toiling hard. His 95 lakhs has been stuck here. He has paid and he is not able to get his flat. This is the condition, my lord. Here,
my lord. Then I think the proper forum is RERA, my lord. With all due respect, my lord. Then I think the forum itself is misconceived.
RERA's order already I have annexed. RERA has directed you first form an association. Now the state say you cannot form an association.
My lord, High Court cannot be reduced to an executing course of RERA, my lord.
No, I think by next date, some of these developments might have happened. He might get his flat. So let's wait, my lord.
Grateful, my lord. Grateful.
Item number 37.
Item 37, I'm appearing today, Millers, on behalf of the OPSC Public Service Commission. I take 4 weeks time for filing of counter.
My lord, the recruitment process will, my lord, begin. So there is urgency.
Only on last occasion, Lordship directed me to serve a copy. They have served a copy and I'm appearing today.
Sanjeev Swain, the council appearing for the Orissa Public Service Commission.
Public Service Commission.
Seeks an advantage. 4 weeks to file a reply.
Lordship, the rate is for the consideration of my representation, my lord, for increasing the upper age limit in the Odisha judicial.
Now after advertisement happened.
So then why don't you do that instead of filing counter?
Yes.
4 weeks time.
Page 25 has made a representation to the OPSC.
That's what. Let them consider that.
OPSC cannot do.
My lord, I have also forwarded
this representation.
So far as upper age limit is concerned, government can consider. Let him file a representation before
the government.
My lord, I have forwarded the representation to the government.
Or you act on this itself. You say the school and mass. Which one? Which department? Sorry.
Law.
It's judicial services examination.
This is OJS examination. This is a fixation of upper age limit with regard to OJS, Odisha Judicial Service.
Lordship, I have forwarded the representation to the OP1 and 3. And I have also submitted the postal
department as a party. Normally GA department issued the notifications. He should have made GA department as a party. Instead of making GA department as a party.
Anyway, the law department government of Orissa will consider the petitioner's representation dated 28 January 2022.
Can I submit one thing, my lord?
Tell us.
Lordship, in page 10, they have the GA department has forwarded the notification.
It's all right. Then ask him to consider it.
My lord.
And communicate its decision to the petitioner. Not later than. When is this exam going to be held?
They have not fixed the deadline.
Now, only in January last week, last date gone for submission of application.
Will you take your decision?
No, the examination date on 27th was the last date. 27th January.
That's over then.
No, my lord.
Registration date is completed, examination not started.
My lord, I have already filed before that 27th.
I am submitting in your
now at this stage representation.
So what will happen, Mr. Kunti, if you now allow his representation? What are you going to do? Can't be just for him. There are thousands of candidates. Can't be just for him.
Admitted fact, I have seen that annexure 1. If may see page 9, that is in his favor. Thereafter, the notification should have been made. But
in page 10,
at least he should have filed a representation before the law department before coming to this honorable court. Instead of filing that representation before the law department, he has filed a representation before the OPSC. OPSC cannot do anything, my lord.
Lordship, I have forwarded the representation to the law department. I have also submitted the postal tracking report in the court, my lord.
We'll consider your lordship may direct so that.
When will you communicate your decision to him?
2 weeks, your lordship.
I don't know. Then you'll fix a date and it will all become practice.
Well,
we just say not later than 28th February.
Well,
2022. The court clarifies it is not expressed in the matter.
For hearing item 38.
May I audible, sir? May I audible, sir?
Yes, please.
Well, this is come in remand from the Supreme Court by order dated 31st January 2017.
Right.
The association of the petitioners has been declared as unlawful association under section 16 of the Criminal Law Amendment Act.
May I place your lordship, last order, my lord, may kindly see.
Yes.
In the last order, there was a direction to file the rejoinder. The petitioner did not want to file in rejoinder, you can proceed.
Rejoinder was filed since long, my lord. Rejoinder, lordship may see, rejoinder has been filed since long.
You didn't get a copy?
2006, 18/10/2006, there was no noting earlier that it has not been solved, my lord.
No. Sir, 6th December. This is about the counter filed on 4th December.
The counter, my lord. This rejoinder date so that 18/10/2006, my lord.
No. They have filed a reply, sir, on 4th December.
Supplementary affidavit.
Supplementary affidavit, my lord. Both sides have filed supplementary affidavit disclosing the present status of the organization, my lord. It needs no further counter, my lord. Only we have all expressed, my friend and myself, regarding the status and present position of the organization, my lord.
All right.
After it is declared unlawful, virtually it is not doing anything, my lord.
All right.
Because
all right, we'll then fix the date. We say, counsel for the petitioner states that he does not wish to file any reply to the supplementary affidavit filed by the state on 4th December 2021. List for hearing on 17th May.
All right. Item 39. Item number 39.
None appears. Dismissal not.
Item number 40.
May I please, madam? Well, in pursuance to your lordship's order dated 24/11/2021, I have filed a representation before the London District Judge, Sambalpur, citing that I am willing to work as a junior stenographer, foregoing my seniority.
Some letter has been given today.
My lord. And I have also
received the instruction that the matter is under consideration in the administrative side.
All right.
Last
Stated that the matter is still on pending consideration on the administrative side. List on, we'll have it very soon.
Last occasion they have taken time.
I know. It's on the here in the High Court. It's pending.
Fine.
List on 7th March.
Pastor matter item number 16.
Copy में भी sir, मैं pardon copy.
Just
copy में भी sir.
Annexure 7, page 50 is the impugned order. Annexure 7, page 50 is the impugned order. Lordship, heard me?
Yes.
Annexure 7, page 50 is the impugned order, by which my representation has been rejected or in the matter of fixation of pay in third promotional post on the ground that I have already received third RSCP.
Right.
Entitled to pay fixation on third promotional post. But your lordship will find that page 47, while referring the matter to the government, the London District Registrar Civil Court has given a statement of my service. Your lordship will find that serial number 5. Your lordship got it?
Yes.
Serial number 5. I held a third RSCP after completion of 30 years. And the last column only grade pay increased to 46,000. So pay fixation has not been done.
All right. Notice, Mr. Mudali accepts notice for the opposite parties. Reply be filed within 8 weeks, adjourned for the next week. 12th May.
Item 24.
24.
Yes.
Item 24, my lord. I'm sorry I couldn't be there at the time.
No, tell us. Arbitration, you have to go in for arbitration.
Yes, sir. If your lordship kindly mark 2-3 submissions, then your lordship can refer the matter to arbitration. Page 81, if your lordship kindly see.
Yes. Yes.
The total amount of penal amount is 36 lakhs 6,113.
Right.
But you first turn to page 86.
Yes, again, same amount.
No, we have requested to, we have paid 18 lakhs 3,057.
Right.
Last but 2 lines.
Correct.
Documents, paragraph page 88, 89. So in that 50% amount has already been paid with an application to consider. But admittedly, there is an arbitration clause at page 37, if your lordship turns to page 37.
Yes.
Any dispute or difference of any nature whatsoever with regard to any right, liability, act, omission, or account of any of the parties hereto arising out of or in relation to the agreement shall be referred to the sole arbitration of the managing director of the corporation or some officer of the corporation who may be nominated by
The
the
jurisdiction is given as Calcutta.
Yes, Calcutta. But if your lordship kindly, one thing can be done. But I am ready and willing to take. But now I have complied with all the directions except deposit of the balance amount, that 50% amount. But I was a distributor for the last 35 years at the time when it was suspended. It has not been terminated, it has been suspended, Malad. I was directed to hand over all the cylinders. But they are bona fide persons. Actually, the allegations against him was a manager was there who has done any mischief that has been done. He has been arrested and on the basis of FIR lodged by me, the petitioner. What I was submitting for your lordship, so if the matter can be resolved in the sense, but mediation is there and arbitration is there. But it can be sent to mediation.
Okay. I think Mr. Acharya will not mind that.
No, I think he will not dispute about it because mediation, if it fails, then we'll go for arbitration.
Right.
What time your lordship may kindly go through clause 37 now, because the allegations as it appears are very serious. The same page 90, I think, my learned senior failed to point out that was considered and rejected. Page 90, Mila. That has been
Still, Mr. Acharya, today, if you want to go in for, because they have already made payment of 18 lakhs out of 36. And they've paid another 9 lakhs after that.
No, another payment I think has not been made.
No, 9 lakhs. I saw that. Or is it only 18 lakhs?
No, that, yes.
18 lakhs. 18 lakhs.
So they've made 18 lakhs. So you can consider. If you arrive at any reasonable sum, it can be settled.
That is not the sole allegation, Mila. Apart from that, other allegations are there.
But you've only suspended them. You're not terminated.
The termination, because of your lordship's order, it has not been, that action we could not take. But the suspension is there. He is not operating since 2010.
No. This status quo will continue during arbitration, obviously.
Yes.
So you will not be able to terminate him till the arbitration is over.
No, your lordship may kindly turn to this page 37 again.
Yes.
Because he has this.
Mr. Acharya, whatever it is, so since we pass a stay order, we'll say that will continue during the arbitration.
After disposing of, I leave it to your lordship, but once disposal is there, your lordship, he may file an application before the arbitrator to that effect.
All right. I'll say that they won't prevent you from seeking mediation in the arbitration.
Yes.
All right.
Can it be mediation first, then arbitration? It will be better.
Arbitration clause is clearly there.
No, it is correct.
Director of the
No, what I was submitting, if in mediation it is resolved.
Different officer has committed some delinquency. Let us say.
There was actually some ego clash with the
Director of the
officer
corporation, highest authority. Can he assume that he can't be impartial?
No, at the relevant time, there was some ego clash, as a result of which everything has happened. Even mediation that can be resolved. I think now officers have changed and people have changed in the meantime.
Mr. Acharya, just give it a shot. Give it a shot. What's the problem?
Is a lady actually. It's a lady quota actually.
The problem is, your lordship, looking at the allegations, they are all very serious. Number one. Number two is the agreement clearly provides for an arbitration clause which may be made to the manager.
No, Mr. Acharya, the only issue is, if you can resolve it in mediation, we'll keep it pending. You give a shot at mediation. If you fail, next hearing will refer you to arbitration.
Arbitration, that's right. I think there is no. I think Mr. Acharya will agree. In fact, if the parties can resolve it amicably, it is the best thing that can be done.
Before the agreement of Mr. Acharya, you are thrusting up.
It's hardly 1 month, 2 months time.
No, it's a public body. It's nothing.
Hardly,
Like,
4 weeks it can wait easily. It's a 2010 matter.
Yes.
It's a parties will appear before the parties through their representatives, authorized representatives will appear before the High Court Mediation Center on 9th March at 3:30 p.m. at 3 p.m. and attempt settling the disputes through mediation.
Right.
It is made clear that if the mediation does not succeed on the next date, the court may consider referring the parties to arbitration.
Right. Highly advised.
Based on 19th April.
19th April. But interim order to continue.
Interim order to continue. Right.
Highly advised.
Okay.
Great.